Today is the 20th of July 2015, calling Bradford Magistrates Courts on 01274 390 111.
If you know the extension you require, please press 0 now, followed by the extension number. Otherwise, please choose one of the following options.
Good morning, Bradford Magistrates.
Hello, I just want to make a quick inquiry if that's okay.
Yeah, sure.
I have some affidavits that I'd like to come down and have notarised at the courts. What would be the best way to come down and do that? Would it be?
I can put you through and we'll make you an appointment. It's done on a Wednesday afternoon, and there is a fee of £25.
Just to have a document notarised?
I think it's now £25 for all of them. It used to be £25 for each one.
Right, okay. So if I have more than one affidavit I want to have notarised, I can do that all in the same bundle?
I believe so, yeah. If you wanted, you could try a local solicitor, as long as he's a commissioner of all, so he can sign them.
Yeah.
They may be cheaper.
Yeah, I usually think it's about a £5 to £10, isn't it, to have it?
Well, I don't know.
Yeah. That's really great, helpful information. Thanks. So that's Wednesday. Is it just to walk in, or do I need to make an appointment on the Wednesday?
No, I'd have to put you through and I'd have to make you an appointment.
Right.
Okay. Because we have a lot of what we call stampings, which is the same thing, and it could be a while.
Yeah, the statutory declarations. So, if I were to come in, how would that go exactly? Would I just stand before a magistrate, make my oath, which is on paper anyway, just read it out, and then what will they? I've already put like date and my full name, so I can sign it for when I get there, date it and sign it for the same day. Will they just give it an official seal on the actual document?
They will sign it to say that
they've witnessed it, right? Do I need to leave any? If I just leave a bit of space on the document for them to do that, with just a bit of free space?
I'm not sure whether they use our own form or not, but they'll certainly go through it all with you.
Right. Okay. Would you put me through and so I can
sure.
and I can have that, make the appointment?
Yeah, just 1 second.
Hello, it's just to make an appointment to come in to have some affidavits stamped by the courts.
I think there's a fee that applies for that. What type of documents are they?
They're just my personal affidavits that I'm wanting to have notarised. So I have 2 of them, and I was told I could bring all my affidavits in, and I think was it £25 to have all my affidavits sworn and stamped.
Okay.
Is that right?
I need to check the fee. I'm not entirely sure of the fee. I can confirm that for you.
Yeah.
Alternatively, you can go before a solicitor's notary.
Yes, I may consider that. I just wanted to double check the price really, and then because is it correct that it's Wednesdays that I have to book the appointment for? That's the day that you do.
I'll need to check. If you can just on the line.
Okay, thank you. Hello.
Yes, it is £25 and it is a Wednesday that we can book them in for, but I've been informed it may be cheaper to go to a solicitor's notary.
Right, so it is £25, and if I've had a few affidavits, I'd be able to come and have them notarised.
Yeah.
Right, that's good, because he wasn't sure, you see, because he did say it used to be that it would be £25 for each one, but that's changed, so I just wanted to double check on the prices of it all really.
It is, so it's the one fee. Obviously you'll need to make the payment before we can book them in.
Sure.
And the fee will be made payable to our enforcement centre, so if you actually wanted to go to it, I can give you our enforcement centre number.
Please, yeah.
Once you've made payment to them, they will give you a payment reference code, and then obviously when you contact us to book that in, you would give us your payment reference.
Right, that's great. What are they called again, lovey?
It's a collection and involvement centre.
Right, okay, collection and involvement centre. And the number for those, please?
It's 0113
0113
307
307
66
66
00.
00. That's great, thank you. And these people will basically take payment for the courts. Is that what they are? They're taking payments for the courts.
Yes, the court don't handle any monies here, and all payments are made directly to the enforcement centre.
Would I be able to make a debit card payment over the phone for the code?
Yes, yes.
Right. Oh, I see. Do you know where their office is based?
It's not an office that you can attend to. They're actually located in Leeds.
Right. Is that within the court buildings in Leeds, or is it just a administration centre somewhere?
No, it's a separate centre altogether. It's not actually located with the magistrate's court.
Right. That's good. You've been very helpful. Thanks very much. Would it be possible to get transferred to Gordon Airy, the Deputy Justice's clerk? Would you be able to do that, or would I need to call back in?
I'd need to arrange that, but I'd need to know reasons why you need to speak.
Well, yeah, I've got some very serious reasons as to why, and this has been going on now since I think March of 2014, and I've had no redress to a certain matter. Now what's happened was a council tax hearing held within the courts in March of 2014, and I went before the hearing and spoke to both a council clerk, not a court clerk, council clerk, and I requested information relating to the complaint and the summons, and she said she couldn't give me that information. The computer was down. It was only for £80, 25 pence of non-payment of council tax. Now, and I wasn't sure, because I was no longer living at the address, you see, that they were billing for. So I tried to stand before a magistrate and request further information, and that didn't go down very well. Anyway, needless to say, I've been in extensive dialogue with Richard Irwin, legal team manager, who has told me that there is no liability order physically produced by the courts, but proceeds to be so like, yes, there is one, but he can't produce a copy. I sent notice to both the council and the courts to produce a copy, a stated stamped and signed copy of the liability order, because it was believed not to exist. So first there was that issue, but the main issue is that during the time that I was doing all this correspondence and CCing it to both the courts and to Bradford Council, making sure that both parties were informed of what my requests were, council tax didn't even reply to the emails until the 20th of August 2014. Can you imagine, from March to August to finally respond? And only to find out that the billing period, liable period, was for April to July of 2013 for a premises that I never even lived at the time, because I left in February. Now, if I'd have got this information right on the hearing date, before the hearing, the magistrate would have may have decided not to have proceeded with the liability order, which they can't produce, by the way. So as far as I'm concerned, I've already deemed notice to the courts and council that the liability order itself doesn't exist. But as far as council tax are concerned, they're not interested. Now they're taking deductions for the amount, including costs, for an amount I don't actually owe. So this is where all the fraud comes in, and the rubber stamping, you see, and the Star Chamber private courts held by the council. And this is these are the sort of problems that are occurring where someone genuinely doesn't owe the money. They're not liable for it within law, and that's what my affidavit is. It's basically just to say that, frankly, I was living at a premises between January 2010 to February 2013, and you're billing me for April to July of 2013, therefore I'm not liable. So you see the problem. So I've gone through months and months and months, made this public record to try and get remedy, had Richard Irwin on the phone, in letters, with some amazing contradictions, incredible, so
Can I just stop
yeah,
there?
sure.
Right, so the process of writing the affidavit is to finalise this problem that's obviously prior to these affidavits being sworn, because if this is obviously the next step for you to actually take, go before
Do you know what, love it? It's taken all these months of requesting basic information that should have been given to me on day dot at the hearing. Before the hearing, it's taken me all these months, and getting close to years now. We're in 2015, so it's been rocking nearly 2 years this, that I've gained the knowledge of just how corrupt the courts are, and any help that you can give me to get basic remedy. For one thing, council tax are continuing to make deductions for an amount I do not owe. That's got to stop. And I need to be refunded. And what my plan was is, having gained the knowledge I've gained on just how the courts work, and that they don't even follow their own CPR rules, and that basically these hearings being held at Bradford Magistrates Courts for council tax are private hearings. The magistrates are, for the lack of a better word, non-qualified anyway, who are rubber stamping and never actually signing any paperwork. It's all a big huge scandal. So I'm going to produce an affidavit stating that I'm not liable for the amount because I wasn't living or resident to the premises at the liable period. And if they can't rebut it with evidence within, is it 14 or 21 days? If they don't rebut an affidavit point by point with evidence, it becomes law. So then they'll have to explain why they're justify taking money out of my account, or allegedly authorised by the courts. The courts have already confirmed, Richard Irwin has already confirmed, that there is no court matter just by stating he has no record. Because unless there's an official seal on the complaint, unless a fee has been paid, unless the complaint itself, the paperwork for that has been produced, there is no court record. Because once a claim has been made to the court and a fee has been paid, then it becomes a county court and it's a court of record, and there is no court record of the matter. So this is how I know it's a private council tax hearing, rubber stamping exercise, a bulk one at that, with hundreds of thousands of people getting shafted for court fees that they're not liable for.
Right, okay, so what is it that I can help you with at this moment?
How could you help me? Because my feeling, my thing is at this stage, and I've already been making attempts to contact Gordon Airy, and it's call back, and I've exhausted it, so I'm continuing to do so. Eventually I was just going to physically go to the courts and try and meet with him in person.
Right, well, can I just take your name, please?
My full name is James, and I've made I can even give you a reference number for the correspondence with Richard Irwin, legal team manager, actually.
Yeah, did you say you could just bear with me a moment?
No problem. Thank you. Hello.
I'm just going to transfer you over to Mr. Airy, if you could just stay on the line.
Thank you very much, lovey. Thank you. Hello, Gordon Airy. You're a very difficult man to get a hold of. I've been trying to reach you since March of 2014.
2014?
Yeah. I've had... Yeah, I don't know where to start now that I've finally got a hold of you, but long story short, I've got a very serious issue, and the only remedy is to either personally take myself to the High Court and make some very serious complaints against Bradford Magistrates Courts and Bradford Council, or to see if the courts are actually willing to address the issues that I've got here to present forth. Basically, it concerns a non-payment of council tax for a hearing in March of 2014, to which I went down to the courts, Bradford Magistrates Courts, to request further information relating to the complaint and the summons, and neither party could provide that information, which is just devastating, and they allegedly went ahead and produced this liability order anyway. After notice of 14 days to produce the dated stamped liability order, I found that it doesn't exist at the courts. Council tax don't have it. Richard Irwin himself has stated that he is indeed responsible for information generated as a result of civil and criminal proceedings, but does not have that information. So basically they've confirmed it's not a court matter. I CC'd correspondence and requests and notices to both the courts and Bradford Council around from May of 2014. Basically, it wasn't until the 20th of August, believe it or not, and by this time, Bradford Council have had all of the correspondence CC'd to them from myself and Richard Irwin, to turn around and finally say the liable period was for the 1st of April 2013 to July of 2013, and I wasn't living or resident to the premises at that time. So all this to discover I'm not even liable for the amounts which they're now deducting from my income, including costs, and there was no court matter. Because there being a court matter involved, there would be a complaint, a sealed complaint with a fee paid, which then becomes a county court. So it's got to a point now where I'm just down to not getting any responses from both Bradford Council and the courts. And when I say communicating with Bradford Council and the courts, I mean I've got 100+ page documented file, which I've sent you in an email actually, with a link to a PDF file that details the whole matter.
Well, I'm not able to access that, sir, because we can't download documents that are...
Right, that's a shame. I mean, I'd be prepared to print it off and bring it in hard copy for you to see, but it's just devastating, the contradictions and lack of due process and these private hearings with these bulk sessions with Really? Well, perhaps you could enlighten me a little bit and try and explain why the courts and the council both make claim to a liability order existing, not being able to produce it for an amount that I'm not actually liable for because I wasn't resident or living at the premises at the time. I'm prepared to make affidavit and issue that to both council and the courts. I need redress to this. I need the money to stop being deducted from the amounts. I need to be fully refunded, and I'll be making further complaints against the courts and council.
Clearly, sir, you're upset, but if I can explain the court's perspective to you, which I believe Richard Irwin did before he retired, but I can't...
Oh, is he retired now?
Yes, he's retired, sir.
Well, that doesn't surprise me. Oh, interesting. Go ahead, please.
Well, I'm not quite sure how that excites you, sir, but...
Well, because it ties in with all the fraud and corruption going on there. I'm not surprised he's been retired or left. It might be retired on the books, but I don't even believe that's the real reason, that's all. That's why I find it humorous. But go ahead, sorry about that.
Right. The law surrounding the consideration of granting liability orders is very, very, very prescriptive, and the court has virtually no manoeuvring room whatsoever.
Well, that's just an absurd statement to make. The court has no manoeuvring room whatsoever in regards to complaints being made to the courts. You realise that that's what you've said?
Yes, sir.
Well, you agree, you know, that's shocking. Did you get my email? I did send you an email making this sort of very brief request. I mean, just the conceptual weight of the file alone means that sooner or later this is going to have to get answered to. The bottom line is that I'm not liable for the amount, and both the courts and council, whether you claim for it to be lawful or not, either way, that issue aside, without questioning the integrity of the courts, I want redress to this matter because I'm not liable for the amount. I'm prepared to make affidavit to say as much, point by point, that basically there's only 5 points, but it's enough to basically say that I wasn't resident to the premises at the time, the liable period that I'm being charged for, including the court costs.
Give me the very slight chance of actually telling you what I was about to tell you.
Yeah.
And it might put it into some sort of context for you. But
Good
I
stuff.
would ask you to be very kind and let me finish what I have to say before you either laugh or cut into me. I'm not suggesting in any way you're disrespectful.
No, of course not. No, please, I want to listen to you. Go ahead, sorry. I'm sorry for interrupting. Go ahead.
No, it's fine. I'm just trying to make a way forward for both of us.
Yeah.
Right. The council tax people levy a council tax across all the registered households in Bradford once a year. Yeah, they do it effectively to work out how much money they need for the year, how much the government gives them towards identify all the people at addresses within Bradford, and then they send out both the explanation of why they want X amount of money based on various bandings and what each household's bill is.
Yeah.
It does include where they know deductions for people who've lived there for less than a year, people who are entitled to certain deductions for single occupancy, and various other benefits that I don't get involved in that cause reductions. So that they send out a bill to every person they have registered at the various addresses in Bradford. So that's the council tax bill that all of us get, presuming that we are, living in somewhere in Bradford. I don't, but I get a lead one just the same. If that's paid, or if there's an arrangement to pay across the year, that's an end of it as long as we pay. Once somebody stops paying, or never paid in the first place, or isn't getting the benefit that they were supposed to be getting, for whatever reason it is, the debt isn't being paid, the council tax people have to prove three things before they get a liability order. Firstly, that the person named is the occupier, and they just show us a document that says, for these 3,000 people, these are the addresses, and these are the names that are registered as being those addresses. We don't actually ask them where they get that information from. They will comply with whatever rules it is. I don't know what the rules are, but it says that Gordon Airy lives at 1 Duff Street in Bradford. Whether it's from the electoral register or what, I don't know. But once they've identified the person, to then tell us how much was the council tax was levied against them, a figure. And then they say, and all or part of that remains unpaid. So once they've proved those three things, the court has no alternative but to grant a liability order. The law doesn't allow us to adjourn, well, it does allow us to adjourn for inquiries, but other than that, the court has no power to say, we don't think you got it right, therefore we're not going to grant it. We have no choice, we must grant a liability order.
So if a respondent comes forth and says that the information is in error, like mine,
Then, chances are we would adjourn the case.
but that didn't happen with me. Why didn't that happen with me?
Let me finish. I'm going back to let me finish, sir.
Yeah.
If somebody attends and says, look, I've paid £500 and you're only showing £300, or whatever the dispute is, we can either grant the order there and then, or what we actually do is we adjourn it for the two parties to go away and discuss it and agree what the actual figure should be. But that only happens if somebody raises an objection. Obviously, if nobody's coming to us and saying there's a problem with this.
That all sounds very good in theory, but that's not how it works in reality, and it's too well documented. It's just too well. That's just not the way it works. If you believe that that's the way it works, and that there's due consideration and due process in there, then that seriously question the competency of the courts. Because for one thing, you're saying that it's the law that you've got to create a liability order based on information that you yourselves cannot confirm, and that you have no power to confirm because all the information's confirmed by the complainant, which happens to be Bradford Council. That's very biased. That's just not.
Every person who the council are intending to apply for a liability order against are sent a notice saying we're going to make this application on a particular date and time at Bradford Magistrates Court. If you wish to dispute.
Yes, but it's all for show. It doesn't actually. It's all for show. The liability orders are going to go through regardless.
You're entitled to your opinion whether it's for show or not. All I'm telling you is what the law says, and we have to comply with the law.
Yeah, but you're not complying with the law. Not really. Not at all. The CPR rules are going right out the window.
Rules don't apply, sir, because it's not a criminal matter.
Well, then it's not. No, the civil procedure rules. This is a.
When you say CPR, we often talk about criminal procedure rules, but you're quite right. There are the civil procedure rules.
Of course there are, and I've made requests under the civil procedure rules for the information, which by law I'm entitled to, and hasn't been provided by either party. So there is no court matter. You understand? For it to be a court matter, there has to be the information. There has to be the actual application to the courts. It has to be signed with a fee paid. What's going on is a massive rubber stamping exercise where there's no actual due consideration, and the lay magistrates are basically sat before Bradford magistrates, before Bradford Council in a room that's pretty much run by the council. When you ask to speak to the clerk, you don't get to speak to a court clerk, you speak to a council clerk. So it's all very dodgy. But in my case, I'm genuinely not liable for the amount. So I need obviously a redress to that, don't I? How do we go about redress? Because I've made requests under the civil procedure, CPR rules, for the information, and that information has never been provided. And the reason that information has never been provided is because that information does not exist.
Okay.
So there is no court, there's no lawful court taking place. CPR 5.4.2, supply of documents to parties, including new parties. The documents should be supplied within 48 hours after a written request for them is received. CPR 0.5.4 paragraph 1, supply of documents for court records. Any party to proceedings may be supplied from the courts of the court with a copy of any document relating to those proceedings, including documents filled before the claim was commenced. The County Courts Act 1984.
The important thing there, sir, before the claim was commenced.
Yeah.
You were making a request after the matter was finalised.
The matter was never finalised. All I did was received a summons. I received no bills. I wasn't resident or living at the premises from February of 2013, and that's what I'm saying. It's all well and good that Bradford Council have followed all their rules in compliance with rules that you cannot confirm. You see what I'm saying? You're saying that this is all lawful because Bradford Council have proceeded lawfully with information that you yourselves cannot even confirm. As it turns out, I was never liable for the period, but it doesn't matter if it was all finalised on their end. What about on the court's end when the complaint's been made? I'm not liable for the amount. I can prove it. I'm prepared to produce a sworn statement before a magistrate and issue it to both the courts and council and get them to rebut it, and they can't because they can't prove I was resident for a place I wasn't living or resident to. You understand?
Clearly, sir, I need to look into this.
You certainly do. Absolutely, you certainly do, yeah. And you need to get back to me promptly because this has been going on for so long.
Not going to be promptly, sir, because I go on leave until the middle of August tomorrow. Could you give me your full name, sir?
Yeah, my full name is James.
And the address the council tax was levied against you, sir? And where's that, sir? And what's the address you're at now, sir?
That's where the summons was sent to, but there were no bills sent to the care of address whatsoever, and I left the premises in February of 2013.
So, which of the premises you left in February 13, sir?
That's what I'm prepared to. I've already written the affidavit, I just need to have it notarised and then issued to both the courts and the council.
So where's that, sir?
That's of...
And the date of the liability order?
Date of the liability order, bear with me just 2 wee seconds, is the 19th of March 2014.
Right.
I can give you the summons number if it helps.
Oh, that would be helpful, sir, yeah.
Sorry?
That would be helpful.
Yeah. Just bear with me a wee tick. Okay. Yeah, the date of complaint as well was the 25th of February 2014. The summons number is 36167
Yeah.
/51884
Yeah.
/385.
I'll just read that back to make sure I've got it right.
Yep.
36167
Yep.
/51884 /385.
That's it. Yeah.
Right. Okay. Contact number, sir. Just read that back again.
Yeah.
Okay, doke. Right. I think we've got enough there to start looking for it.
That's
One of the one of the things we have, you see, is that a lot of these documents are filed in date order rather than name order, so at least now I can look on the date order to see what documents we have.
Right. Okay. Well, I have.
If I did a trace and follow, I'd find nothing at all.
Right. Okay. That's interesting. Because the summons number is you see, the summons itself is printed by Bradford Council.
Yes, it is.
And it says Bradford Magistrates Courts, HM Courts and Tribunal Service on it. So my understanding of the law, as it really works, is that in itself is actually fraud and perjury. That's fraud right there. That's a fraudulent summons.
It isn't, because whether it's civil or criminal proceedings, the party taking the action issues the summons. We authorise it, and I authorise. I get a list of ones where the three criteria are satisfied, and they wish to have a hearing date.
Yeah, that's the problem. It sounds to me like you're saying that there's due consideration because you're checking that the three criteria that are required that are in place. But the information relating to those three criteria, the information, all the process is conducted is by the complainant themselves.
But that's true in any case, and then once that's commenced, then there's the opportunity for the other side, let's put it that way, to say that's incorrect. And if that person is there to make that, then we have no choice but to accept what the applicant is saying to us.
And when somebody when
any sort of case.
Mm-hmm. Well, I certainly went down to the courts and objected. That's
When did you go, sir?
on the hearing date, before the hearing date, and spoke to both the council clerk and tried to speak to
On the hearing date or on the hearing date?
on the hearing date before the hearing, and basically I didn't get the summons until last minute. Like I say, it's a care of address. I've never actually lived at the premises, so when I did receive the summons, and there were definitely no bills. If they did, they went to the last premises if they were ever sent out at all. So I just basically received this summons. I think it was just a few days before the actual hearing day. I thought very interesting.
We're required to give you 5 days notice, sir, so that doesn't surprise me particularly.
Well, yeah, so I thought very interesting. Well, I don't have time to go down before, so I'll go down on the date, request the information, and there was no information. See, the problem is that how am I supposed to dispute the matter unless I have the information myself? So
They would have had a computer printout showing all the names, all the addresses, and all the amounts.
no, I was told the computer systems were down. I says, well, you can't proceed with the liability order then. She went, it's going to be granted. I went, how can it be going to be granted when I haven't had the chance to object yet or even see the information relating to the complaint?
Well, they must have had at least one copy, sir, because they have to give it to the
Absolutely not. Do you think the magistrates in there for these bulk hearing sessions have the information in front of them before they make a decision? No, they don't. They have a council clerk who's telling them that it's all gone through right.
Well, they have a council clerk, and they put forward to the court the computer printout with all the applications on.
And what about when the computer systems are down and they can't do that?
Well, all I can assume, sir, is that the print is on the previous days.
Honestly, sir, this information should be able to be pulled out off in a breath within 48 hours on request.
We would still see the computer printout, so we wouldn't grant them without them.
Look, I'm not really. I mean, we could debate the lawful proceedings and how that happens. For sure, I've got the evidence that proves it's all fraud and corrupt. I don't want to debate that way. The reason I'm speaking to you is basically I'm not liable for the amount, and how the hell are we going to sort it out when Bradford Magistrates Courts and Bradford Council so far have just proven to be just nowhere near forthcoming in terms of redress of this matter whatsoever.
Right. Okay then. I'm not quite sure what answer you want from that, sir.
Well, I'm hoping that basically you'll be able to actually deal with the matter, just to.
Is we either did or didn't grant a lawful liability order. As to the amount that is owed, that is purely between you and Bradford Council, and the only way you can challenge that is by going to a rates tribunal.
Well, why?
By going to the High Court.
Well, if I produce an affidavit that states I'm not... I mean, I wasn't living or resident at the premises, and I'm prepared to make an affidavit to say as such.
Well, you can make, with respect, you can make as many affidavits as you like. I've told you that if we are told you are the person, if we are told that the money hasn't been paid, if we are told there's a lawful claim of council tax, we cannot refuse the liability order.
So the complainant can make it...
No, this is my term, sir. If the amount owed is in dispute, that's a matter between yourself and Bradford Council, and if the figure is disputed to a degree that you can't come to an agreeable compromise, you go to a rate tribunal and not to the magistrate's court. It's a complicated process, I fully accept.
Well, with all due respect, the liability order should have never have been created in the first place, and now that information has come forth that puts you in error, the courts are in error.
There might be an error, sir, in respect of the amount owed. There might be an error in respect of the named person, but those are the issues that you take to a rates tribunal and not to the magistrate's court. Because we have no choice but to grant the liability order. The liability order itself is permission for them to contact you and to take various steps to enforce. If you want to challenge that, you take it to a rates tribunal.
That's outrageous. Have you any idea of what you're saying? These just not lawful corporate...
I have no idea what I'm saying, because I've only been doing the law for 42 years, so I'm just making up as I'm going along.
Well, this is... No, do you know what it is? It's been going on this long that you've all become complacent with it, thinking that it's actual lawful court proceeding.
I never consider my job to be something I can be complacent about. I'm on task every day, and any decision I make is subject to challenge, so the last thing I'm in any subject is complacent.
Well, let me state the facts. The facts are there is an alleged liability. There is an alleged liability order for an amount I'm not liable for. Flat out. Those are the facts right there. And you're telling me, in order for me to get redress, in order for me to have my money back that they are deducting from my income, that they are stealing from me, as I am not liable for it, and the costs, whether they're lawful or not.
Look into the matter. What you're doing now is, with the greatest respect, wasting your time and my time, because until I see what the papers say, I can't talk in specifics at all about your case, because I don't have the specifics in front of me.
Exactly, and I didn't have the specifics in front of me when I went down to the hearing. Exactly, thank you. Yes, exactly.
Allow me the opportunity to get the paperwork out before we consider this text any further.
Exactly, and do you know, if you'd have had that attitude in the first place, we wouldn't be here talking about it now.
Well, I've been happy feeling we would be, sir, but let me have a look at it first.
Excellent, you do that, and I look forward to your call back. Thank you very much for your time.